Greetings to everyone present. My name is Ankit Malhotra. I am an advocate and a Felix Scholar based in India, and I am truly delighted and honored to be able to deliver this paper on criminal law and its intersections with business and human rights. I am also grateful to the organizers for allowing me to share a recording of my paper. I am truly gutted to not have been able to be in Cornell and deliver this in person. Having said so, I'd like to proceed swiftly with discussing the main agenda for this paper and set out its expectations as well, which discusses these different cases as you see on your slides on terrorism financing and the ability to pay these fines as well. In instances such as the French company Lafarge, in its common and extraordinary positions, as an example, serves it to links of atrocities to the 1600s. On the other hand, criminal courts have also regulated and extremely inconsiderate towards these cases, situations. Of course, this is something which you see now gaining traction, and that has been the agenda with the table that you see on your slides as well. This paper will seek to discuss the main trends in the regulation of corporate involvement in atrocity crimes, how do these trends overlap, which patterns can be distinguished, and also the approaches that can be defined that look at these concepts that shape the analysis and described method in this paper. In sum, I will look at four trends and also end with a conclusion with suggestions on how these atrocities with corporate involvement can be looked at a much deeper and a much more nuanced level. Without wasting further time, I'd like to begin this paper by suggesting that atrocity crimes, which include war crimes, crimes against humanity, and genocide, which are the core crimes of the Rome Statute, were developed to overcome the constraints of legalistic and political debates about the classification of violent acts, such as genocide, for instance. So, atrocity crimes involves all these crimes, but does not narrow it down. Therefore, while atrocity crimes as a phenomena is still considered criminal, it does offer a legalistic approach which benefits from the social realities of atrocity crimes instead of the legal technicalities. As such, atrocity crimes is a useful analytical category unfined by fundamental underlying characteristics, such as being large scale, systematic, and situated in specific political, ideological, and sociological contexts. Many jurisdictions, such as the International Criminal Court, do not extend to legal persons, which would, in its entirety or its understanding, look at corporations as well. Therefore, corporations roughly can be involved in atrocity crimes in the context of repressive states during or after conflicts and wars. Most of this involvement is indirect, meaning that the corporation or its agenda do not commit acts that constitute themselves as atrocity crimes by in and of themselves, but rather contribute to these crimes. Such indirect forms of involvement consist of, for example, financing actors that commit atrocity crimes, such as the ISIS in the Lafarge case discussed above, or can also include, say, for instance, provisions of chemicals, such as in the Van Arnott case or the Hussein involvements or the insulation ovens in the top case, or the surveillance equipment in the IMC's case, or the involvement in including killing by private military forces, say for instance in Blackwater in the case of Iraq. There can also be situations of enhanced interrogation by the Titan and Kachi in Abu Ghraib. Corporate involvement, in essence, is involvement in atrocity crimes that can thus constitute a wide variety of harms in highly multifaceted phenomena. Regulation in this instance is defined, or at least attempts to define, the intervening factors in business activity within the framework of the state's rules and norms to prevent and or at least limit corporate involvement in atrocity crimes or to create accountability for such involvements. Thus, in a broad definition, because a narrow or more state-centric definition would not capture the broad array of interventions that are of interest. Moreover, a broad definition allows for an approach to regulate the involvement of different types of power regulations that might or might not lead to set up rules or norms. An analytical focus therefore lies on the potential of interventions to change business activity that leads to corporate involvement in atrocity crimes. What therefore becomes important is to understand trends, or at least the lack of cooperation in regards to understanding trends and adapting legislation in this respect. One can go back far as to the 1600s to look at the Dutch and British East India Companies. The involvement that they found themselves in could perhaps in some instances be classified as atrocity crimes. Take for instance the ships of these companies, the vessels of these companies, which were used to obtain an income and return on investment for their shareholders. Their leaders and personnel carried out state decrees to obtain power and produce. Among the most prominent cases of colonial violence and killing and dispersal and abduction of at least 10,000 inhabitants of the Manda Islands of present-day Indonesia. Insofar as one was to go back to 1740, thousands of Chinese were slaughtered in Batavia because of the instigation of the British East India Company, the Dutch East India Company in this instance. There have also been similar remarks being made by the British East India Company and the involvement of large-scale atrocities. India's first Prime Minister noted candidly in one of his allocutions, where he said that the verb to loot was introduced in the English language because of the conduct of the company in India, from Hindi loot meaning spoils of war. As joint stock companies operating as state chartered organizations, the East India Companies enjoyed the right to wage war, sign treaties, mint coins, exercise justice in conquer territories. The British East India Company's services to protect overseas warehouses involved into private armies that became the principal tool for territorial acquisition. Therefore, what one can note in this regard is that the company cannot carry on trade without war, nor war without trade. The British and East India Company, the British and the Dutch East India Companies were profit-driven entities. Both were intrinsically intertwined with their home states. Therefore, the activities conducted by these companies were mutually beneficial to the home states and were not inclined to attempt to prevent or end the atrocities in the company's conduct. The conduct was already criticized as being unfolded, unfounded, and existing in a regulatory vacuum. At an international level, the symbiotic relationship between commerce and state and the state during colonial projects gave rise to the newly developed international law that enabled and justified colonial atrocities rather than regulating them. Hugo Grotius, the author of the Jure Parde, which contained the Mare Liberum, notes this in his regard as well, that stemmed for a need to justify the 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 Dutch East India Company's violence against Portuguese, British, French, Spanish competitors, including those in the indigenous peoples community. The Jure Belli Paxis, the law of war and peace, has a fundamental commercial and interpretive understanding in this regard as well. The British and Dutch states' attempt to limit or end the excess of the East India Companies was limited to fraud and corruption but not atrocities. For this, states relied on self-regulation. In Britain, for instance, the more prominent 18th century economist Adam Smith saw the British East India Company as a flawed commercial operation that lacked by design the pressures for good conduct he ascribed to the free market in his seminal work Wealth of Nations. He noted that a government by merchants and political tyranny that the company embodied to be incurably faulty. The limited criticism did not amount to social capability of contributing to an end or to limit the atrocity crimes associated with the companies. In 1798, the Dutch government took all control of the debts and assets, and so did the British East India Company, which lost its charter, and the British government took direct control over India in 1858. What this suggests is that the lack of international and domestic regulation of corporate involvement in atrocity crimes is a trend that started in the 17th century but has persisted in the present day as well. Internationally, there is limited political will to create a binding legal framework at the international level. This also includes the inability or unwillingness of states to regulate corporations, both in the state which the atrocity takes place and also in the home states of the corporations. Therefore, what one can be stated is that atrocity crimes will remain unregulated, and the economic factors that help them would rather exercise reverse regulation directed at safeguarding a corporation's continued contribution to the commissions of atrocities persists. Take Shell, for instance, and its involvement in apartheid in South Africa, which the perpetrator state facilitated and directed Shell's continued involvement. It did so, for example, by making the publishing of any oil related information a criminal offense. This made it more difficult for the world to detect Shell's continued deliveries on which the military and economy were dependent. Also consider the role that was played in the DRC in the Second World War, where the government sold concessions to mining corporations for areas over which they had no effective control, so that the corporate payments to rebel groups could be almost inevitable. Also consider home states which are reluctant to regulate their businesses abroad. Shell's home state against Britain and Netherlands first resisted an oil embargo on South Africa and then failed to observe its effective use and control. Lafarge, as above mentioned, is a case by French authorities to go through with its payments to ISIS in order to be able to keep on operating in the region. Another striking feature is between 1600s and today, the multinational corporations continue to represent their home country's interests abroad so that they are linked to atrocities with the tacit approval of the country's headquarters, which tends to be in their own country. What thereafter happens after the Second World War is an acknowledgement of these efforts, specifically in June of 1947, when the French military tribunal sentenced two directors of companies to 7 years and 5 years prisons for crimes against humanity and war crimes. Then between 1947 and 48, there are more than 40 industrialists from the three largest companies stood in trial in Nuremberg. These trials became to be known as the industrialist trials. As such, Nuremberg is widely seen as foreshadowing the extension of responsibilities under international law to corporations, forming the start of accountability and involvement in atrocity crimes. German banks, for instance, and other financial institutions, while did not lead the focuses of these cases, the executives of Deutsche Bank, Deutschen Bank, and the leaders of corporations such as Siemens, Daimler-Benz, who had been used in tens of thousands of forces of slave laborers, were never indicted. The prosecution of individuals working for subsidiaries of non-German companies were never considered, even when they had used forced or slave labor. Therefore, what this leads to is the establishing of a concurrence of individuals and corporate responsibility in the Nuremberg cases. To assess the Nuremberg industrialists as regulation, it is valuable to consider in what ways was accountability at these trials potentially functioned as a social control to prevent and or at least limit corporate involvement in atrocity crimes. Threats in the Cold War intensified. For example, in 1948, the Soviets which took power in Czechoslovakia, creating unrest on how far the communist takeover of power would reach. Fundamental hesitancy to adjudicate businessmen for atrocity crimes rose further. In this instance, Judge Morris became involved in the IG Farben trial, who told a German journalist after his retirement that a bunch of eager, selfish businessmen that you would find in any country should not have been tried in Nuremberg. Therefore, what this reflects is that the judges in the IG Farben case opposed the idea that those driven by profit motives as opposed to ideology should not be sentenced for atrocity crimes. Finally, there was also a general fear that sentencing corporate actors would deter German and American industrialists from working with the US government on Cold War projects. What then happens in the 1950s is the US High Commissioner for Germany, John McCloy, who issued a declaration of clemency to all those businessmen still imprisoned, which were released later. In 1957, one of them features on the cover of Time magazine in the accompanying article by then the richest man in Europe and heralded as a savior for the Western German economy. What you also see on your slides is a summary of all the documented criminal complaints, investigations, court cases against corporations and or individuals, corporate actors for involvement in atrocity crimes since Nuremberg. From this, the overview becomes clear that only a small minority of corporations that might be involved in atrocity crimes ever runs into prosecution, or other authorities that make the case in this violation of international criminal law. Few individual businessmen and corporations have ever been convicted for involvement in atrocity crimes. Be that as it may, what becomes extremely important to understand is civil society labeling and engagement. During the 1970s and 80s, the global anti-apartheid movement was among the first to point its arrows to corporations that did business in and with South Africa. These corporations were accused of supporting the apartheid regime economically, militarily, and also carrying out apartheid policies, thereby sustaining the legitimacy of the rule. IBM, General Motors, Shell, Barclays all were accused of enabling apartheid. Civil society organizations sought to encounter the inaction of North American and Western governments, which were reluctant to put pressure on their Cold War ally, South Africa. In this context, the behavioral responsibility and the take on concepts of corporate social responsibility must be taken seriously. Actions were therefore directed at getting corporates to leave South Africa, but an effort therefore later was made to facilitate ethical business practices in and with South Africa and the apartheid state. This is drawn out further in the Sullivan Principles issued by the United States of America in 1977. Human rights activists were also documented of how corporations in South Africa and countries such as Argentina, Brazil, Chile were assisting the military juntas, thereby identifying and detaining enemies of the regime, those such as the union leaders and their members. Look at the case of Mercedes-Benz and Volkswagen in the 1990s, who were outwardly labeled and in a legal sense being involved in crimes against humanities under authoritarian regimes. A prominent case in this respect will be the Royal Dutch Shell case and the violations and responses in the Ogoni people who were protesting against extensive environmental damage caused by oil spills in the Niger Delta. Throughout the 1990s, allegedly, at Shell's directions, the Nigerian police and army committed crimes against humanity against civilians. Therefore, all is not that dull because under the Alien Tort Claims Act of the United States of America, signed in the 1990s, non US nationals can effectively file civil suits for compensation for torts that amount to violations of international law. And this brings prominence to the victims of slave labor and Nazi looting, which sued corporations such as Volkswagen and a number of Swiss banks in what is often referred to as slave labor and restitution cases. These cases ended in settlements. However, the Kulumani case over 20 companies were sued and for their involvement in apartheid. Shell has also been sued under the ATCA for the aforementioned atrocities in Nigeria, and in 2015, the US Supreme Court ruled that the Alien Tort Statute does not extend to foreign corporations such as Shell in the Cubal case, since this avenue for regulation has now been closed. However, in 2000, the NGOs involved in publicizing such matters focused their attention on DRC, thereby informing consumers that their mobile phones and other electronic gadgets contained what was known as conflict material. These minerals, mostly cobalt, tin, tungsten, talmud, and gold, were described as funding the various armed conflicts in the Great Lakes region. They were essentially fueling the conflict of war crimes and crimes against humanity. With this, a whole sector was now labeled as being at risk of involvement in atrocity crimes. The conflict minerals campaign was so successful that the initiators managed to convince the US legislators to include a provision in the 2010 Dodd-Frank Act so that all US companies needed to investigate and report on the origins of at-risk minerals they used in their supply chain. This was the first mandatory reporting obligation specifically relating to corporate links towards atrocity crimes. Therefore, similar cases have also been brought forward to identify another pattern, which only a handful of civil cases have had desirable outcomes on accountability. What therefore must be noted is that in context of reparations and repression of conflict, it is increasingly labeled as corporate involvement in atrocity crimes, and perhaps is exemplified in societal and corporate sections and reactions in 2002's illegal invasion of Ukraine by Russia. A substantial number of corporations with a presence in Russia quite quickly decided to leave Russia off their participation and involvement in the region. But they still continue to do business in or with Russia, are accused, therefore, of assisting in the war effort. Russia non-sanctioned activities are also being labeled as international sponsors of war in an effort to damage the reputation of corporations that indirectly assist in or contribute to the Russian war effort. These increased social experiments have been accompanied by an attempt to institutionalize norms on how businesses should behave in context and conflict of oppression and war. What then prompts us to look more deeply at itself is an institutionalization of norms, which perhaps begins with business and human rights as a movement rooted within the trunk of international human rights law, which institutionalizes these regulations to curb adverse effects and impact on human rights. This regulation of atrocities can perhaps also be noted in the aforementioned Dodd-Frank Act, which looks at this much closely, but also the European Union's initiatives in this regard to look at legislations which it enacts in 2001. But perhaps the most important principle in this regard would be the UN Guiding Principles on Business and Human Rights of 2011, which looks at civil society organizations, states, businesses, and represents the first agreed global standards that spell out conceptually and practically the responsibilities of both states and corporations in this regard, and also the impact on human rights. Therefore, the corporations which do not have direct human rights obligations must do so as well, Instead, they have what is known as corporate responsibility to respect human rights and also a non binding social expectation. What therefore must become most important in this regard would be to perhaps look at these principles at much more depth. Say, for instance, those between 15 and 21, where corporations are expected to implement the human rights due diligence process by which they continually check, seek to address, and potentially negate human rights implications that their practices have. This non binding format has provoked countries such as France, Norway, Switzerland, Germany to adopt principles in this regard and have mandatory regulation to curb these practices. One may look at me as far as the French duty of vigilance law in its most far reaching aspects includes a liability provision as well. One must also look at the interest that NGOs played as an interested party in this regard. One may also look at corporations that have not improved its ways within 3 months that can complain against a lawsuit in a court, which can then order a company to comply or face penalties. Such has been the case in Netherlands, where there have been considerable resistance against a proposed reform that would be opposed strongly by Dutch businesses. However, what perhaps becomes the most critical thing to note is that the business and human rights movement over the last 2 decades have upended the regulatory landscape of corporate atrocity crimes by institutionalizing norms and elevating soft law norms to proposals for hard law implementation. Drawing on post growth theories and insights from climate justice, this may eventually lead to a fifth trend in regulation of corporate involvement in atrocity crimes, in which regulation is fundamentally reimagined. Therefore, to conclude, what one can suggest is that the four main trends in regulation of corporate involvement in atrocity crimes overlap patterns and recover themselves in a multifaceted way that harms those associated with corporates, thereby looking at this at a much broader lens through atrocity crimes, in addition to the wide variety of corporations and the sectors that need such regulation. First, we've seen that the decades of perseverance and the variety of civil society actions that can limit the continuation of involvement in atrocity crimes, and in the case of Shell in Nigeria as a way of example. Second is the scenario of the perfect storm, where a state and civil society actor come together and look at them more closely. A remaining question is where we go from here. We can offer insights into what works by studying the regulation of this type, but also look at the factors such as environmental crimes and harms, money laundering, or even terror financing. Atrocity crimes serve themselves as near inevitable consequence of corporate and stakeholder capitalism, geopolitical interest, and a symbiotic relationship between corporations and states. Parallel in tandem with developments in fields of business and human rights, economics, and environmental studies. We need to study alternatives and imagine thoughts through scenarios that can, for example, break up power of corporations vis-a-vis states. The general public and legal procedures in this regard are critical. It has therefore become clear that liberal capitalism's invisible hand has been too invisible to address corporate involvement in atrocity crimes. It is therefore time to roll up on different sleeves at different levels. With those words, I once again thank the organizers for giving me an opportunity to share my thoughts and perspective. I am truly delighted to have been able to share my thoughts and nonetheless remain my misfortune to have not done this in person. Thank you.